Ruby, for your leadership. An icon. She's a treasure, and she's someone I very, very much admire. So thank you so much. And the school is great. We actually had a 91% bar passage rate on the July bar exam. 95% of the students have jobs 10 months after graduation. And our students have some of the highest entry credentials in the school's history, a 3.75 median GPA. And a median 1 LSAT, which is almost 80th percentile. And the students represent every corner of our state, our nation, every ethnic, racial background, every gender. So it's a school for the people. It's a school that it's a public university. It's a school that's always been here to educate the city of Houston, the residents of the city of Houston, the residents of the state of Texas. And we're very proud to continue that mission. So that concludes my remarks. I will be getting ready for the judges to come in I guess maybe 5 minutes or so. But again, really thank you. Thank you for all being here, and it's for all of us to learn what the court does. Thank you.
state of Texas, this honorable court.
Please be seated. The Supreme Court of Texas is pleased to hear argument in cases here at the University of Houston, at the Law Center, and the John M. O'Quinn Law Building. We have been at the University of Houston Law Center several times, and most recently in 2017. In the 1891 Constitution of Texas required that the court sit only at the seat of government in Austin, but the Constitution was amended in 2001, and since then we have taken the opportunity to sit as frequently as we could, usually once a semester, in outside of Austin. We got waylaid a little bit by COVID, but we're back on schedule and we're pleased to be here this morning. We have two cases to be argued. First is 22-878, Myers-Woodward versus Underground Services Markham from Matagorda County and the 13th Court of Appeals District. And then 2367, Sterry versus Etheridge from Harris County and the 1st Court of Appeals District. The court has allotted 20 minutes for each side in both arguments, and we'll take a brief recess between the arguments. We're ready to hear argument in 22-878.
May it please the court, Mr. Truling will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal. May it please the court. Two mineral deeds are at issue in this case, a 1947 mineral deed and a 1947 amendment. Neither deed explicitly mentions salt. As is typical for a mineral deed, each deed refers generally to oil, gas, and other minerals. Yet USM asks this court to craft default rules that would specially benefit USM as a salt mineral owner over every other mineral owner and even lessee in the state of Texas. There's no reason here for any default rule. This court may resolve the issues in this case based on the plain terms of the deeds themselves and on this court's existing precedent. Under the 1947 amendment, Myers enjoys an NPRI, or non-participating royalty interest that gives it a royalty of 1/8 of all minerals produced. There's nothing ambiguous about that language. What that language literally means on its face is that for every 8 units of production, 1 unit belongs to Myers.
What is your response to the argument that the absence of the delivery language has an impact on this?
This court has long recognized that what matters is the fact that the royalty percentage gives the royalty interest owner the interest in the royalty itself, or interest in the production itself. The delivery language is unique to oil royalty clauses, and oil royalty clauses are in fact in-kind royalty clauses. But the reason for that delivery language is that frequently in the 1900s, crude oil production would be delivered to a pipeline, and the pipeline would then pay royalties under a division order. But that delivery language doesn't frame the requirement for an in-kind royalty. This court recognized as much in the Hyder case, and the Hyder case involved an override, and the override simply was a royalty interest in a fractional share of the production itself. And this court recognized that that was in the nature of an in-kind royalty interest. Now, as a royalty interest owner under an in-kind royalty interest, Myers could, if it wished, take physical possession of its royalty share of the oil. Most royalty interest owners, including Myers, don't have either the practical ability or the facilities to take physical possession of a ton of salt or a barrel of oil. The Wolf cases back in 1936 out of the 10th Circuit recognized that if the royalty interest owner can't take physical possession or doesn't take physical possession of its royalty share of the production, then the producer may sell all of the production, including the royalty interest share, and account to the royalty interest owner for the royalty interest owner's share of the proceeds. Texas courts, like the Cook case out of the Eastland Court of Appeals, have adopted the reasoning in Wolf, and the reasoning in Wolf makes sense. A producer can't produce all 8/8 of the production, sell it all, and then pocket the 1/8 share that belongs to the royalty interest owner. The producer can't sell 8/8 of the production and take a windfall off of that 1/8 share that literally belongs to the royalty interest owner.
If the royalty owner could take that 1 ton of salt, or however many it would be, presumably that person, Myers here, would sell it.
Absolutely.
And so if the producer in turn is selling it, would it not be sensible to say that the price that the market would bear for that ton of salt, regardless of what the producer does with the 7 tons that the producer has, that is what the royalty owner gets?
I think what I would say in response to that is that the lessee is marketing all of the production, including the royalty interest share, under the implied marketing covenant for the benefit of the royalty interest owner. And what that means under the implied marketing covenant is that the producer must obtain the best price reasonably available for all, including not only the producer, but also the royalty interest owner.
Isn't market value a much more objective measure, though?
Market value may be an objective measure, but this court, going back to Vela, has long recognized the distinction between market value and proceeds. Market value is something that the parties may negotiate for, but the chief problem here is that this is a 1947 deed, and the deed on its face contains no reference at all to market value. Parties under a lease, parties under a deed may negotiate for a market value measure. That's not here. The trial court ultimately got it wrong by rewriting the 1947 deed to insert language that's not there, market value.
But if the 1947 deed, under your theory, presumed the idea that you just have that ton of salt, it wouldn't need to talk about market value, because the theory would be you would get the market value by selling it.
Oh, and again, if I take physical possession of the salt, I can sell it for whatever price I want to.
Which would presumably be the market price. Maybe not. Maybe you could sell it for less. Possibly you could get a better deal. But the assumption in the law is you'd get market value, a willing buyer and a willing seller for a ton of salt, right?
I would disagree with that, because this court said in Vela that there is no presumption that a sale is going to be for market value. The market may enable a seller to obtain more than market value. And in that instance, if the producer is able to sell 8/8 of the production for a better price than market value, because the producer under the implied marketing covenant is marketing all of the production, including the royalty owner's share, the royalty owner under Wolf and under Cook is entitled to participate in that benefit that the producer obtains by selling for more than market value.
If the producer sells for less than market value, is there any argument that the NPRI would have to be made whole in a sense? Or is like, nope, you just get, they made a terrible deal, and even though on the market you could have sold it for 5 times as much, you're getting a fifth of the market value because that's the deal that was struck by the producer?
No, and really that's kind of the Cook case. The Cook case says the implied marketing covenant does require the producer to obtain the best price reasonably available. But sometimes the best price reasonably obtainable is not, in fact, what others might consider to be market value. And as long as the producer adheres to its obligations under the implied marketing covenant, then the producer's done what the producer has to do.
But what's the obligation under the implied marketing covenant?
The implied marketing covenant requires the producer under any lease or deed where the royalty is in any way measured based upon the royalty owner's share of the proceeds, the producer must obtain the best price reasonably available using the...
But what's the difference between the best price reasonably available and the then prevailing market value?
Because market value does not necessarily mean the equivalent of price or proceeds, as this court has long recognized, including in the Vela case.
So leaving aside the value of the salt and how to calculate the royalty, whether in kind or market value, there's an asset created by extracting the salt. And this asset is the cavern underneath, which can be used as a storage cavern. And I know your client's position is that the landowner should have the right to any cavern created as a result of the extraction of the salt. And I think the other side's position is, look, it was our labor that created this storage facility by extracting the salt, and therefore it's our storage facility to do with what we would like to do, which would presumably be the same use that the landowner would put it to, which is storage of natural gas into the future. Why should we adopt the Court of Appeals rule and your rule in this case?
Well, I think the court has already recognized, going back to Humble Oil and Lightning Oil more recently in 2017, that it is the surface interest owner that owns the exclusive right to storage of non-native materials. Now let me explain what I mean by that. Under the mineral lease here, under the 1947 mineral deed, Claude Hamill received the mineral estate for the purpose of mining, drilling, and operating for minerals. Claude Hamill received all of the oil, gas, and minerals as part of the mineral estate. What he did not receive under the mineral deed was any empty space. This court has long recognized, going back to Getty Oil in 1971, that the surface owner owns all of the space above the surface and below the surface. That's the default presumption that this court has applied for years. Nothing in this mineral deed enables the salt interest owner or any other mineral interest owner to use the estate for anything other than the extraction of minerals. Now, no one disputes in this case that USM has all of the attributes of a mineral interest owner as Claude Hamill's successor in interest. No one disputes that USM may use all of the surface that's reasonably necessary for it to carry out its rights as a mineral interest owner. No one disputes that USM may use its salt caverns for purposes related to extraction of minerals. The dispute here is really whether USM can do something that no mineral interest owner in Texas has ever had the right to do: operate a commercial enterprise for the storage of oil and gas hydrocarbons, which is not the mineral in which USM has any interest. USM says, well, there's no harm here because there's no evidence that its proposed activities in storing hydrocarbon in the salt caverns will make any difference to the surface interest owner. Of course, the parties never had the opportunity to develop that evidence because the case was resolved at the summary judgment stage based upon the terms of the deeds themselves. And regardless, this court shouldn't have to make policy decisions that would affect other mineral interest owners based upon an undeveloped record. As a matter of common sense, and what commentators have pointed out, is that necessarily the commercial storage of hydrocarbons is going to cost the surface interest owner some degree of intrusion. There's only two ways to get crude oil onto a property, a piece of property, for storage. It's either got to be trucked onto the property or it's got to be piped onto the property through a pipeline. Either way, that's a tremendous burden to the surface interest owner that they wouldn't necessarily expect under a 1947 mineral deed that just says the mineral interest owner has a right in oil, gas, and other minerals.
Well, you say we shouldn't resolve this as a question in connection with leases other than yours, but as I understand it, there are caverns all across the Texas Gulf Coast, all of which eventually, some now and some eventually, are used for storage. Obviously very valuable assets, especially as the economy moves toward exporting liquefied natural gas. And the Court of Appeals in Beaumont has a different rule than the Court of Appeals here. So doesn't it make sense that we would come up with a rule that would apply to the coast, the Texas Gulf Coast, consistently?
Well, and I think this court already has. In Robinson in 1974, it recognized that the mineral interest owner can enjoy all of the 5 attributes of the mineral estate, which is anything related to the extraction of minerals. That doesn't keep a mineral interest owner or anyone else from developing caverns or doing some other commercial enterprise above and beyond the extraction of minerals, as long as they get the consent of the surface interest owner. That's been the rule under Robinson, and that's why commentators such as Professor Eugene Kuntz and Professor Bruce Kramer have said, look, the mineral interest owner only gets the right to extract minerals, native minerals, from the property. Non-native minerals and the storage thereof is something that necessarily adheres to the surface interest owner, and the mineral interest owner has the ability to acquire it. The public policy factors that are in play here are no different than they would be to an oil and gas owner who wants to operate a wastewater facility for disposal of oil and gas from other properties. A mineral interest owner can do so, but under Robinson, it's got to get the surface owner's consent. I'll reserve my remaining 5 minutes.
Any other questions?
I had just one. Is there, if they put hydrocarbons into this storage cavern, can you produce salt from it still?
There's no evidence in the record. My answer is no. If they're using it for oil and gas storage, they're not going to be producing from that cavern. They may be producing from salt deposits elsewhere. And in this case, USM has taken out permits to try to create 23 different storage caverns under the property based upon salt deposits on various areas of the property.
Any other questions? Thank you, Mr. Keeling. We'll hear from the respondent.
May it please the court, Mr. Jefferson will present argument.
Mr. Chief Justice, and may it please the court, and if you'll permit me, may it also please Justice Sondag. I'm very pleased to be here today. I would like to focus on the property concept of fee simple ownership, but of course invite any questions that the court has on any other topic. I brought a demo with me, if you'll excuse me. This is what we're talking about. It is a solid mineral. This is the dome. If you think about it as the dome that underlies the property, it is completely salt from top to bottom, from left to right. There are no natural caverns within this. Any cavern that is created is due to the labor and incredible expense of USM, United Salt Mine. USM owns that property in fee simple.
And do you own the property, or do you own the minerals?
The mineral.
So it's a step further to say that you own the space created by the extraction of the mineral.
It is the mineral, and the mineral is completely comprised of salt. So when the conveyance occurred in 1947, it was a conveyance of the entire salt formation.
Minerals?
Of the entire salt formation, which is a mineral.
For the purpose of mining, drilling, and operating for said minerals.
Including together with all and singular the rights and appurtenances that are that come with a fee simple conveyance.
But the empty space is not a mineral, right?
The empty space is not a mineral, but the entire formation was conveyed. And so what we do with that property is exploit the mineral, and we exploit it for our purposes.
But if the formation is conveyed, it seems like we would have said something different in Lightning Oil, where we said the surface owner owns the underlying reservoir storage space.
This is unlike, this is not a fugacious mineral. It's not like oil and gas. And so in that circumstance, oil and gas is contained within rock formations, within the spaces of rock formations. And the way I think about it—
But it's also a formation.
Yes, but the way I think about it is the mineral owner of oil and gas, the oil and gas owner, has the right to extract it, but it doesn't own it in place. Unlike the salt dome, it is a hard mineral. It is owned in situ, is the way the courts describe it. It is owned in place, the entire formation. Oil and gas is contained and trapped within, it's like within a sponge, if you can think about it that way. It's in the sponge, you can squeeze it out, you can extract it, but after you're done, the sponge remains and it's part of the surface owner's property. That's always going to be the case. The sponge, that physical structure still remains. But with the salt, we're entitled to not only remove it, but use the salt. And the caverns, we're using the salt. The only way that you can store hydrocarbons or gas or hydrogen, as you say, along the Gulf Coast. This is where the U.S. Strategic Petroleum Reserves are stored. The only way you can use it is to use the salt because it is an impenetrable barrier, and that's what makes it so suitable for the storage of hydrocarbons, liquid natural gas, and oil.
I don't think anybody's suggesting that you wouldn't use it. It's just a question of who gets paid for the use.
Well, if the court will understand the way I understand it, at least, fee simple ownership, once the salt formation is the mineral. Once it is transferred and conveyed, it is that owner's obligation, that owner's right to use it for any lawful purpose. I think the best case that I can think of for this, and the most analogous, it's a persuasive authority only, is the New York case, International Salt Mine. There the question was the same as here. There was a dispute about who owned the caverns that were created. And the way the dispute came about was a third party wanted to store its ash in the caverns that were created by the salt mining operation. And so there was a declaratory judgment suit brought. And the question to that court is the same as the question here. Who has the exclusive right to use the caverns? And the Second Circuit said many years ago, it is the mineral owner that owns.
And that would make sense because there the mineral owner has the exclusive right to use the cavern to mine salt. But here, your client's trying to use the cavern not to mine salt, which is going to hurt the surface owner because they're not going to receive the royalty interest that they're entitled to on the mining of salt if you use it for some other purpose.
The surface owner does get the royalty interest. They reserved a 1/8 royalty, and we are paying a 1/8 royalty.
On the storage of hydrocarbons?
For the salt. For the salt. That is all that they carved out of the fee simple ownership.
But you can't use
clarification. When your client extracts salt and thereby makes a cavern that it then wants to use to store, is the wall of that cavern salt, or is the wall of that cavern the rock formation?
The wall of that cavern is salt.
So your point basically is, look, we get all of this salt, and if we go in and take out some but not all of the salt so that we create a cavern that is made all of salt, we get to use that salt any way we want, which includes putting stuff into that cavern and using the salt in essence to hold
the hydrocarbons. Is that
Exact-
your point?
That's the point, and the majority
So
rule.
if your client went in
by
and
the way.
extracted all of the salt, I don't, geologically whether that's possible, but if it were, to go in and extract all of the salt, leaving only limestone, shale, whatever the rock formation would be, you'd concede that your client would have no right to use that cavern to store hydrocarbons?
Yes, and that is the rule of international salt, and not only of international salt, that's the majority rule. If you go
What
to
if there's a tiny little
Kentucky-
bit of the rock that's showing on one side? If it's mostly, if it's 95% salt but 5% rock?
Well, there are rules about cavern storage that apply. The Railroad Commission would not permit that, and the storage of hydrocarbons. You couldn't do that with a little tiny amount. There has to be, and there are distances and rates about how thick the salt has to be in order to obtain a railroad permit. And you have to renew, the Railroad Commission comes in and inspects every 10 years to make sure that remains impermeable and can't escape. So
But isn't the
it's all or
bigger
nothing.
isn't the bigger problem with the theory that you would be incentivized to not extract the salt, which is, after all, what the surface owner's interest is in having you exploit the mineral for your mutual benefit?
This court said in Harris and many other cases that if the ownership right is fee simple, we have no covenant, no obligation whatsoever to extract salt at all.
Is it truly in the nature of a fee if it goes away or lapses once all of the salt is extracted? If you were to extract the salt, I read your briefing to say your interest sort of vanishes, or it lasts only for so long as salt remains.
That's correct. It is a fee simple interest in the salt. And so if salt remains, we control the salt and the cavern. The majority rule that's stated in international salt and several other states is that if in fact you deplete that salt and all the salt is gone, then yes, you have no more interest in that as opposed to the surface owner, because the salt is gone. But this is a very critical point. Yes, we own the salt. We can decide not to mine it at all, ever, and they have no right to force us to do so. We can decide to mine it and pay the royalty interest and profit from it through the mining of the salt alone. Or we can decide that the best use of our mineral that was granted in fee simple is for storage purposes. The best use of the salt is to maintain that barrier because it is a very incredibly profitable enterprise.
But the storage is not in the mineral. It's in a cavity within the mineral.
The storage is completely surrounded by the mineral. And so we are using the mineral as the fee grants us the opportunity and right to do. We're using the mineral to its best purpose, and it is a lawful purpose.
So could you store poison gas or nuclear waste, assuming you could get a permit for that, and the landowner would have no recourse for that?
Well, yes, this is a fee simple estate. And so
you would have to presumably get it across the surface somehow in order to put it down in the cavern, right?
You can do whatever you want with the property. You can use the surface reasonably. This court
said, for the purpose of mining, drilling, and operating for said minerals.
That's in the habendum clause. The phrase preceding that is the conveyance is of the 8/8 interest, that's fee simple, together with all and singular the rights and appurtenances thereto in any wise belonging. This is
with the right of ingress and egress and possession at all times for the purpose of mining, drilling, and operating for said minerals.
The habendum clause cannot take away the fee simple ownership. That is expressing one way you can use the surface. But the preceding phrase, I think, is the critical one, and that is, it is a fee simple that gives you, together with singular, the rights and appurtenances, the caverns are appurtenances thereto in any wise. You cannot have a broader clause than that.
But the mineral is gone now.
The mineral is not gone. The mineral remains. The mineral has to remain in order to store the hydrocarbons.
Well, but you're not wanting to store it within the salt, that salt
You are.
block.
You are storing it within the
No,
salt.
within the cavern.
The cavern has salt around it. That's
Right.
what makes the cavern
Correct.
functional
Right.
as a way to hold hydrocarbons.
Right.
This court said this is not in our brief, but it's in 1890, and I'm going to quote from Calcasieu, "The ownership of land, when the estate is a fee, carries with it the right to use the land in any manner not hurtful to others, and the right even to lease it to others, and therefore derive profit, is an incident of ownership."
But your client doesn't own land, it owns minerals.
Yes, this
Right.
applies to minerals as well. This is,
So what if your client extracted salt from under this surface and put it in a warehouse forever, it would never own any royalty whatsoever to the landowner?
that's
Lessor.
correct. If it doesn't sell it, that's
And
correct.
does it have an implied obligation
No.
to market and sell it?
No.
So your position would be that under this lease language, your client could go in, extract a bunch of salt, put it in a warehouse, and never sell it, and would never own any royalty, NPRI royalty whatsoever.
Correct. It would be an unusual circumstance where
could it-
we wouldn't profit from our own salt.
Right.
So I
Could
don't
your client use
see
it
that.
for its own purpose and never sell it?
Yes.
I mean, if your client makes pretzels and wants to put a lot of salt on its pretzels, could it extract salt under this lease, chop it up, use it for its own pretzels and never sell it, and it would never own a royalty?
That's correct.
interest?
It's our
That's your
property to
position.
do with as we will, and
And it
including,
it only owes the royalty if it sells it.
yes,
to a third party.
that's correct, including never selling it. They have no right to it. They have no right to force us to sell it. It is completely fee simple. That is property 101. Since we're here in this Augusta Law School, this is the way a fee simple works.
So your theory would be your client could take the salt out, use it to construct a huge warehouse made of salt, and store hydrocarbons in that warehouse, and never own a royalty. And that this is no different than that, because it's what it's doing is leaving the salt in the ground, essentially, to create the cavern, rather than constructing a cavern on top of the surface.
So physically that would never happen because you can't expose salt to the elements. The salt here is a mile underground, and that's why it's protected from the elements. It's protected from water. That wouldn't happen. But the answer to the question is yes, we could do with the salt whatever we want to do with the salt, and that is a feature of the grant. Today, if I were property owner today selling land, I would make sure, and this happens all the time, that I reserve a right to profit from the use of the cavern. That would be true today. But if in 1947 you are the seller of a fee simple interest, you have in mind, once I sell this, I no longer can control it because I'm giving up my right to the current use, mining operations, or to any future use, because I am giving the right to the new owner to do what it wants with its property for any legal purpose. Nuclear waste, yes, but if the nuclear waste damages the property, there are tort remedies. There are tort remedies for that. And we shouldn't disturb property law with a whole nother category of tort law that accounts for any unreasonable destruction or unreasonable use of the surface.
In severing the mineral estate, is it contemplated that the mineral estate owner can burden the landowner by using it to create a benefit of storing third-party gas?
Yes, the same way as in the Second Circuit in storing third-party incendiary ash, yes. And it has to be a reasonable use. It's got to be reasonable use. The principles of accommodation apply, and those could be litigated. We worked hard, and the record shows, we tried to negotiate with Myers on the use, both on the royalty and on the use of the property for many years, and it didn't happen.
If you owned it outright, why did you need to negotiate for the use?
Because we're trying to do this litigation-free. This is what you always do. But we also, and this is true along the Gulf Coast, those that own the mineral interest outright whether or not they negotiate for a use. They own that property, and they own the caverns, and they have the exclusive right to use it. And you can't do both. The owner, the surface owner, cannot ever use the caverns that we create while we are engaged in mining, because it is our exclusive right to use these caverns. And it can't ever use our caverns as long as salt remains, because the salt we are using for a profitable purpose that, as you point out, is the future of the energy industry.
Doesn't Robinson suggest that that use needs to be for something that pertains to this property?
No, and I'll tell you, if we're correct about how we look at international salt and Kentucky cases and Ohio and Pennsylvania.
Well, the Kentucky cases, they're using the coal, they're using the shafts to produce coal.
In Kentucky, they say you can transport foreign minerals.
Right, that would be contrary to Robinson.
Into the shafts outside.
So that's not Texas law.
No, it's not Texas law. Of course, we're asking the court to look at this as persuasive
and
not to
overrule Robinson?
And not to be an outlier. You don't have to overrule Robinson. Robinson didn't deal with a hard mineral like this, where there are no spaces inside the mineral. We own the entire salt formation. And once, if that is clear, and you understand that we own it in fee simple, Robinson doesn't apply. And
Well,
none
Robinson
of the fugation
says outright, nothing authorized the mineral owner to increase the burden on the surface estate for the benefit of additional lands, and that would be, gas coming in from somewhere else.
But Robinson is not dealing with a fee simple ownership in a hard rock mineral with the dominant mineral interest in addition to the fee simple ownership and the reasonable right to use.
On that question of the nature of the fee simple ownership, did anybody know that this cavern was there in 1947?
Likely not.
And so your case would be simple if we know there's a salt formation there and the deed says, I'm selling you my salt formation. This would be a lot simpler, but a lot of the theory underlying oil and gas law is that we don't know what's under there, or at least we used to not know, and that's where oil and gas law arose from. And so does it matter that nobody knew what was there? Does that affect the nature of your ownership right in what turns out to be there later?
So I think it does not, because of the nature of fee simple ownership. And the example I would give is fracking. In the 1930s, you don't know about fracking. It's a new technology that comes in place. And yet, once it comes, you're still entitled to use fracking, break up the rock, and suck out the minerals and gases with this new technology.
But you can't.
No one's thinking about it before.
You can't do it on the neighbor's land. Through this.
Justice Johnson's opinion, I can't remember the name. It's not a trespass if you frack on the neighbor's land and it goes into an adjoining land. You don't know where fracking is going to happen, but you do have the right to capture the oil and gas under your property with any new technology.
But under Robinson, you can't capture it from another property and then bring it in that way.
Right, but Robinson doesn't deal with there's no way that this formation is ever going to be on an adjacent property. You don't have to worry about that.
But the hydrocarbons you're storing are from other property.
Yes, but that's our right. Just as Calcasieu said, you can lease it and bring other property on. In all the cases that we talked about, Ohio, New York, not Texas law, I understand. But you can bring foreign materials on. If in our property, during the mining operation, you decide to store diamonds, in your cavern, that doesn't give them the right to use it simply because it's not a mining operation. The question is, who owns the formation? Who put the blood, sweat, and equity into creating a profitable use of these caverns?
But that's irrelevant under the lease language. Whether they put in the blood, sweat, and equity to create the cavern can't be what you rely on here. What you rely on here is that they own the salt that creates the cavern, right? I mean, I'm figuring out how that matters.
I'm just spinning the hypothetical, but you're right. We don't need to get into that. You can look solely at the general conveyance language, the addendum clause, which recognizes the grand conveyance, and also recognizes that you have the right to all the appurtenances thereto. It's the broadest language you can possibly imagine. The parties can contract for something different, but under this lease, they didn't do so.
If we don't agree with that construction of the lease, your briefing suggests that we're going to be risking the economy and the nature of hydrocarbon storage and all the rest of it, but I'm not sure why that wouldn't be addressed by the very kind of negotiation that you said that you engaged in to avoid litigation. Why wouldn't it just be a matter now in which the surface owner and you would share in the profits, but we wouldn't destroy the ability to preserve hydrocarbons?
I would look at the Enbridge amicus brief. These transactions have already happened, and millions and probably billions of dollars have been spent under the precedent that MAPCO established back in 1991. This was the set law of the land, and these operators are not just dealing in Texas.
Well, to be fair, most commentators have said it's a pretty unsettled question even after MAPCO.
I grant it, Your Honor, and that's why we're here. That's why we brought this petition to you. There has to be an answer. What I'm trying to advocate is the best answer is to join the majority of jurisdictions that have already answered this question. Settle it once and for all. The idea about the contract is it's a future going. Once salt has been used and recognized as a valuable place to store caverns, then you have these negotiations. Surface owners don't want to sell in fee simple any longer. I understand that. I wouldn't either, once I know that this is a proper use. But we're talking about this period between 1947 with the fee simple and today. The fee simple never changed, so the ownership rights never changed. And we don't want to disrupt the law of property going back from 1947
Well, for everything from 47 onwards, there's a statute of limitations. I assume you're not going to have disgorged profits from the storage that's not within that period.
No, but these grants are here today in the 1947 form. And they were here when Enbridge was negotiating its properties.
I'm only asking about the possibility that the disruption would be something that would have harm that transcends the financial interests of the parties. And I'm just not sure I understand why that would be, because we're just now saying, all right, the ownership was not clear before, the Supreme Court has now settled it. It means that both sides have to engage in something, and they both would be incentivized to do that because it's apparently a lot more valuable than the salt.
I would think it's because, take our example, our reliance interests. When we acquired the property and we understand the value not only of salt, but of caverns, that's when we had the right to accelerate the production, to create these caverns, knowing that the profit is not only in the salt. We'll pay their royalty. They don't come away with nothing, but we understand that the profit is not only in the salt, but in the future. Hydrocarbons, hydrogen. This is going on forever. So we have invested in this with the awareness that the caverns are ours to use in fee simple, and that's why we're engaged.
And the royalties that you're paying seem awful low. I don't want to open up a big thing, but he spent a lot of his time talking about that question, and we haven't really addressed it yet. But $16 million in salt production they get for an eighth, $260,000. That doesn't sound like an eighth, really. Can you just defend that briefly, because I know it's going to come up in the rebuttal?
So I think the answer there is Devon Energy. If the parties had intended, I'm quoting from Devon, that the royalty owners would receive royalty based on the market value at the point of sale, they could have said so. If they had intended that in addition to the payment of market value at the well, the lessee would pay all production costs, they could have said so. I don't think this court is in a position to second guess their negotiations or what happened in negotiating the royalty or the value of it. There's only evidence of our evidence. Their expert witness was struck. So the court is dealing only with the evidence that we showed of comparable royalty market value in the area, looking at comparable properties. And I think that's the best way to evaluate this royalty question.
Any other questions? Thank you, Mr. Jefferson. Mr. Keeling, you have 5 minutes.
A few brief points. USM characterizes its argument as the majority position. It has itself quoted Professor Tara Righetti's article, and Professor Righetti's article points out that, in fact, USM's position is the minority rule. Other coal-producing states like Virginia and West Virginia have rejected USM's position. USM relies on a handful of cases from other jurisdictions. It notes International Salt today. International Salt was a case that didn't even address the ownership question. It pushed off the ownership question entirely. What International Salt said is that, look, under that New York Second Circuit jurisdictional analysis, there was no offense to the surface. There were coal stretches underneath that the court ruled the coal owner could use for the coal owner's purposes, and there was never going to be any offense to the surface estate, which would never even know what was going on below the surface.
So here, though, the mineral owner is creating an improvement to the surface estate, creating a valuable asset to the surface estate that they invested millions of dollars to create. Are you saying that the surface estate owner takes ownership of that improvement without any recompense to the mineral owner?
Well, let's be clear. The mineral owner, even in fee simple is not unique to mineral ownership. Fee simple applies to the surface owner as well. What the mineral interest owner gets is the 5 attributes of mineral ownership. And none of those attributes have anything to do, of course, with hydrocarbon storage.
But they've spent a lot of money and constructed what is an improvement to your estate, and you're saying that they're not entitled to anything in connection with that value that they've created for your estate?
No, for 2 reasons. Remember, number 1, the mineral interest owner gets the dominant right to use the property, even the surface owner's rights, ownership rights, for the purpose of developing and extracting minerals. No one questions that. So as long as the caverns are in an area where they are extracting salt, Myers can't come in and itself open a commercial storage operation that would offend USM's rights to extract salt. At the same time, remember this, all mineral interest owners spend money to erect improvements on an estate. That doesn't change the fact that under this court's precedent, the improvements that the mineral interest owner constructs are for the purpose of extracting, improving minerals. That's what this deed says. The use of the word appurtenances, which appears in almost every mineral deed, doesn't change the nature of the mineral interest. The mineral interest owner is still entitled to the 5 attributes of mineral interest ownership, which don't include a commercial operation for the benefit of other producers on other properties.
You agree they had no obligation to extract salt from this land?
Oh, as a mineral interest owner, they had no obligation to do anything.
Right. And do you also agree that if they extracted salt and stuck it in a warehouse for 1,000 years, they would never owe your client a royalty?
If they didn't sell or otherwise use the salt in a way that would entitle us to royalty, then I would agree with that. The royalty interest is still.
What is the way that would? What are the ways that would entitle your client to royalty? They have to sell it, right? I mean, if they stuck it in a warehouse and did nothing, your client would get no royalty.
And here's the problem with that hypothetical. We own 1/8 of the minerals. That's a fractional interest in the minerals themselves. So if they stock it in a warehouse, effectively what they are doing is failing to comply with their implied covenant to market, because the implied covenant to market would require them to sell it and otherwise pay a royalty on that 1/8 that belongs to Myers.
To clarify a point on the royalty calculation, is it right that the expert's opinion that was relied on below completely ignores the actual sales and the actual prices at which the salt was sold under the cost-plus arrangements? Or is that data point somehow folded into the analysis but just not weighted heavily?
We have complained about USM's experts' calculation of market value under what the trial court said the value of the royalty was.
And does that calculation completely disregard the actual historical sales?
It does. It relies entirely on royalty agreements between USM and other royalty interest owners. A royalty agreement is not a comparable sale of salt. By definition, a royalty agreement is a conveyance of an interest in real property. To have a comparable sale, you've got to have a sale of the same product in a similar location of similar quality under similar terms. A royalty conveys a prospect.
I just want to make sure the answer to my question is yes.
And it is. I apologize, Your Honor.
To go back to Justice Blacklock's question, what's your position on what a surface owner who's parting with a mineral interest would have anticipated in 1947 about whether he or she was parting with the ownership of spaces within hard minerals?
In 1947, candidly, I don't think that Claude Hamill or the predecessor owner of the surface estate would have had any idea that there would be an attempted use of empty space beneath the surface.
But what would if they had wanted to look at that question, what would the case law at that time have indicated about the ownership of underground spaces?
Under 1947 case law, there was precious little for anyone to deal with. I think the closest analogy may be the Moser case, and the Moser case involves uranium. And in Moser, this court said, look, under a conveyance of oil, gas, and minerals, the surface estate owner isn't reasonably going to expect that the mineral estate owner is then going to tear up most of the surface in order to extract uranium. It just wouldn't have been in the mindset of the surface interest owner back at that time. Same point here. I don't think it would have been anywhere in the mind frame of the conveyance in 1947 that any of the parties would have reasonably expected that salt caverns eventually would be used for the commercial disposal of hydrocarbons.
If we adopt your position, would that create an incentive to destroy the utility of the caverns by just getting all the salt out that can be gotten out, thus making it impossible to get the Railroad Commission permit that Mr. Jefferson was describing as a certain amount of thickness and all the rest of it?
Realistically, I can't imagine that a mineral estate owner would shoot itself in the foot in that way. The simplest way for a mineral estate owner to be able to develop a salt cavern for the storage of hydrocarbons is the same way that oil and gas producers get to use expired wells for the commercial disposal of wastewater. They go to the surface owner and they negotiate for an arrangement that allows that. It's not terribly expensive. You've got evidence in the record of USM's predecessors doing exactly that, agreeing to pay the surface estate owner a certain percentage of
So I mean, it creates a negotiation, of course, but if the negotiation, I mean, we'd be essentially giving a veto to the surface owner. So we know for sure that we wouldn't be expanding this valuable resource of salt domes, and we might be shrinking them because the surface owner could say, I refuse to give my consent, or nope, I want all the salt out, I want to bring this back to, farmland or whatever. If we know that adopting your position is going to diminish, maybe not that much, maybe some degree, but it's going to diminish something that's really valuable and hard to create, does that not augur in favor of retaining the MAPCO rule?
Well, number one, MAPCO doesn't say that. It says nothing about commercial storage. It talks only about ownership. And in that respect, it is inconsistent with lightning oil and umble oil. I wouldn't call the right of the surface owner a veto right at all. It's just the right of the owner to be able to be involved in.
Isn't it literally a veto? I mean, if the owner says, I'm not going to permit it under your theory of ownership, they can't do it. That's what I'm getting at.
Well, and I suppose that's correct.
And maybe property law requires that, but that's the implication, I think, of this. We know for sure that under the current status, the MAPCO approach, we have this very valuable thing that benefits national security and so on and so forth. Under your approach, we'll have somewhat less of it. Maybe not that much less of it, but less of it. Now, I'm not saying that that necessarily compels one answer, but to the extent that that affects a common law decision, doesn't it favor the other side?
That's true in a vacuum, but that's true because that's what Humble Oil and Lightning Oil say. And even in the context of Humble Oil and Lightning Oil, even if you buy into USM's argument that there's a difference between stationary minerals and oil and gas production itself still extracts oil and gas from pore spaces that can be used for storage purposes. And oil and gas producers under Humble Oil and Lightning Oil already know that if they want to store oil and gas on someone else's property, they need to involve the surface estate owner. Humble Oil and Lightning Oil simply clarify the law on that point and let everyone know who they need to go to negotiate those rights. To create USM's position would be to make the law less uniform and offer confusion in where a producer must go to determine who it negotiates its storage rights from.
Any other questions? Thank you, Mr. Keeling. The case is
very much.
submitted, and the court will take a brief recess.
All right.
Good meeting you. Thank you.
Ladies and gentlemen, if you could please take your seats. Ladies and gentlemen, if you could please take your seats, the court will be out momentarily. If you could please take your seats and come to order, please. Thank you. Ladies and gentlemen, if you could please take your seats and come to order, please. The court will be out momentarily. Again, if you could please take your seats and come to order, please. The court will be out momentarily. Please take your seats. All rise.
Please be seated. We'll hear argument in 2367, Sterry versus Etheridge.
May it please the court, Ms. Drake will present argument for the petitioner. Ms. Guzman will present argument for the amicus. Petitioner has reserved 5 minutes for rebuttal. Ms. Draper will open with the first 10 minutes and present the rebuttal.
Mr. Chief Justice, may it please the court. Care, custody, and control. These words are seen throughout Texas and United States Supreme Court case law to detail the fundamental rights that parents have in this country. We are here today asking this court to protect those due process constitutional rights. This case illustrates that a lifetime protective order against a parent as to her children acts as a de facto termination of parental rights without the constitutional protections of a termination proceeding.
How is it like a termination when the parental rights are still there for pretty much all purposes other than what's set out in the protective order? So how is it a termination order?
All of the rights related to care, custody, and control have been stripped away from Ms. Starry. She has retained no meaningful rights to participate in any way in the child rearing decisions or in the lives of her children.
Isn't a modification possible if in fact her behavior were to improve?
The problem here is with the process of getting to this point, and the fact that there is a modification option available does not save it from the constitutional infirmities of this process. She has been stripped away completely of all the key fundamental rights of parents, and on any modification in a protective order setting, the burden is going to be shifted to her. And now she has to prove and try to chip away and get back those rights, which she lost in a very flawed process to begin with.
If we said go back and do it on clear and convincing as opposed to preponderance standard, would that be enough?
It would not be enough. There are a number of constitutional infirmities in this process, and just implementing a clear and convincing evidence standard is not going to resolve those.
What else do we need for a protective order? Are you saying we cannot do protective orders at all, or what else would you add?
No, the concern here relates to a protective order over 2 years. Typically in Texas, protective orders are 2 years or less, and a court may issue a protective order for longer if it finds there was an allegation of a felony involving family violence. Just an allegation. If you have a termination proceeding, you are going to have 12 to 18 months to conduct discovery. You are going to have the clear and convincing evidence standard. The most comparable provision of the termination statute under Chapter 161 of the Family Code relates to, you have to prove by clear and convincing evidence.
Excuse me, are you saying that a protective order can be ordered simply upon an allegation of these heightened requirements?
The 2-year or longer protective order is available if it is alleged that there has been family violence, something that would constitute a felony offense. It does not require serious bodily injury or death, which is required by the comparable termination statute.
But it requires proof.
Only by preponderance of the evidence.
Right.
Right, more than an allegation. There has to be a finding.
So anyone who practices family law knows that allegations of violence are rampant. We see them every day in family law cases.
But
burden,
what we're getting at is that's not enough.
Correct.
There has to be evidence. There has to be proof, not a mere allegation.
There has to be evidence by just a preponderance of the evidence standard.
No, that's what's required upon proof, not the allegation.
The preponderance of the evidence standard, the court must find by preponderance of the evidence that the person committed a felony offense involving family violence.
Correct.
The preponderance of the evidence standard is part of the constitutional infirmity in this case. The United States Supreme Court has been clear that when you are going to terminate parental rights, you need a clear and convincing evidence standard.
So would you say that if a parent is the one who is having the protective order entered against him or her, if it's longer than 2 years, it needs to be clear and convincing, or if it's 4 years or 8 years or what? Where do we draw the line?
Obviously, this case involves a lifetime protective order,
Sure.
but I believe that the constitutional infirmity lies with the statute that allows for a protective order longer than 2 years. The United States Supreme Court recently considered the case of Rahimi, which dealt with the constitutionality of civil protective orders in the context of firearms. And in that case, the United States Supreme Court, while they upheld the ability to restrict firearms in that case, they were very clear that it was only applying to the specific facts of that case. Rahimi's protective order was only 2 years. And the temporary nature of the protective order was critical in the determination of why they could strip those constitutional rights.
So in this case, apparently there was evidence that indicated that when the children were staying with the parent, she grabbed one of the children by the back of the head and beat his face on the hardwood floor. Is that right?
So, Your Honor, I would encourage you to look at the record as a whole. And yes, if true, some of the facts alleged in this case are heinous. However, if you look at the record as a whole, you will see that there were a number of due process violations that prevented Ms. Starry from putting on an adequate defense.
With respect to other due process violations, like I think you point out, not the unavailability of a jury trial and discovery. Those are the two that I saw. Was there ever any objection posed to going forward with a bench trial or any attempt to seek discovery that was declined by the trial court? So were these two challenges preserved in the trial court?
So these two challenges are deficiencies in the statute. You are not entitled to a jury trial under the Family Code in a protective order proceeding. And the statutes require a quick trial. Depending on the county, we're looking at 14 to 20 days for a protective order. I use the term trial lightly. It's really a final hearing. There's no opportunity to conduct discovery when you're looking at that timeline.
Was that argued in the trial court that that was a constitutional deficiency with the statute?
It was not, but that does not constitute a waiver because you cannot waive your constitutional rights. Additionally, Ms. Starry...
You can't waive your constitutional rights?
I do not believe that a constitutional right in this nature can be waived. However, she was not on notice that a lifetime protective order was a possibility in this case because nobody even requested a lifetime protective order.
I did notice that it seems to be that it's totally up to the trial court from what the statute says in terms of if the trial court makes the findings for an over 2-year protective order, the judge can make it as long as he or she wants. Is that, because it says may.
Correct, and the statute is very open-ended. The ex-husband, when asked about it during his testimony, indicated he believed it should last until they reached the age of majority, and after that the children could decide for themselves.
Is there any precedent that sets a standard of review for the may of how long it goes? Any courts of appeals that have said, what a court's supposed to consider in terms of how long it should be, or reversed ones that are too long?
I'm not aware of any precedent that specifically addressed that. The only other cases out there dealing with these types of issues were for protective orders that were not permanent in nature. No state Supreme Court anywhere that we could find has addressed the issue of a permanent protective order that impacts parental rights.
But isn't it common that other states do have similar statutes?
I don't know if there are similar statutes.
Having to do with protective orders?
I'm sorry, what?
Having to do with protective orders.
There are certainly different protective order statutes in different states, and I do not know what states have comparable protective orders. What I do know is that the most closely analogous case law from any state Supreme Courts or other jurisdictions out there relates to, they use the term guardianship in these other states, but it would be the equivalent to conservatorship here. And the courts in all of those cases did not find they violated constitutional rights because the parents were able to modify and terminate those guardianships at any time. There were no restrictions on their ability to do that. Here, even though the mother could technically modify, that's just to modify the terms. It's very limited what she could do. The statute only gives her 2 opportunities to try to vacate it. And at that time, the burden has shifted tremendously to her. She's been stripped of all of these key core constitutional rights, and now she has the burden in only 2 opportunities to vacate under the statute to try and get those back.
The children could seek relief?
The children could, but the ability of the children to seek relief does not in any way impact the constitutional violation against the mother in this case.
How do we think about a situation where you have a protective order and then potentially either a criminal conviction under a higher burden of proof, other standard of proof, or a termination proceeding where the state actually comes in and meets the burden for establishing termination? How does that impact the protective order? Does it have a curative effect? Is it irrelevant? How should we think about that?
So our position is that the solution to the constitutional infirmities of this statute are to require the clear and convincing evidence standard of a termination proceeding and to require a conviction for felony violence, family violence involving serious death or bodily injury, or community supervision. The reason for those...
Do we require a conviction in connection with the termination of parental rights? In other words, doesn't endangerment alone constitute grounds for termination? You don't have to prove a final conviction.
The most comparable ground, based on the facts of this case, for a termination proceeding would be under subsection L, and that relates to a conviction. Whether or not there are other grounds that could have been alleged, there might be. There are, I believe, 25 different grounds for involuntary termination of parental rights. But in a termination proceeding, that is a whole different ballgame from what happened here. Usually those cases are going to take 12 to 18 months. You're going to do discovery. You're going to have an opportunity to put on a complete defense. Your criminal case, many people who have a protective order have a criminal case pending in those 14 to 20 days when they have to have a hearing.
Isn't your argument really protecting the parent over the rights of the child not to be harmed?
No, Your Honor, there has to be a balancing act here. And there are other constitutional mechanisms for protecting children and other victims of domestic violence without this statute. A lifetime protective order is not necessary to protect children from imminent danger. We have temporary protective order, we have injunctions and SAPSR proceedings, bond conditions if someone is under criminal indictment. There are a lot of constitutionally tested processes that could have been used in this case and could be used in this case if this court vacates the protective order if it is appropriate, which I do not believe the facts support that. But I realize this court must look at precedent for all protective order cases, and you will have a concern for the safety of victims, as we all do. That does not negate the constitutional rights of parents, and they must be protected. I see that my time is up.
Any other questions? Thank you, Ms. Draper. Ms. Guzman, we'll hear from you.
Good morning, Mr. Chief Justice and may it please the court. Termination of parental rights has been described as the death penalty of civil cases. And that description fits because what's at stake is the fundamental liberty interest in the care, in the custody, and the control of our children. The lifetime protective order here raises serious and critical constitutional questions because it effectively terminated parental rights without the safeguards of a termination proceeding. One is not a substitute for the other.
Even if, I wonder if it's even worse than termination, because if your rights are terminated in a conventional parental termination proceeding, your legal right to the children is extinguished, but you can still write them a letter. Or say hello to them at the grocery store, or which she can't even do that.
Let's make no mistake, and that's exactly right, Justice Blacklock. This order is permanent and it's forever. And Justice Ferris noted in her dissent that this is worse than a termination order because even when these children turn 18, they can't see their mother if they want to because their mother may face criminal prosecution. A parent's fundamental liberty interest in her children doesn't vanish when she faces serious allegations of abuse and investigation, or even when those familial bonds are weakened.
Well, there was more than allegations of abuse here. She was indicted for injury to a child, and there was testimony that the trial court believed, and it had to believe in making a finding that a felony had occurred. So if we agree with you that there's a higher evidentiary standard that should apply because of the rights that are at stake, what do we do for purposes of resolving this case? Should it be remanded to the trial court for a new trial? Should an appellate court endeavor to review the record under a clear and convincing evidence standard and determine if there's enough evidence to meet that standard? What should we do?
This court should remand this case after it reviews the record and is convinced, assuming the court adopts the clear and convincing standard, that this trial court formed a firm conviction and belief in the allegations. She didn't allow an offer of proof. She limited cross-examination. She didn't allow a witness to testify about Mr. Etheridge's own violence. That goes to credibility. The question here is not whether a lifetime protective order is ever available in any case. Certainly in the boyfriend dating relationships, those are available. They shouldn't be subject to the same scrutiny. But the parent-child relationship, that's fundamental. The question here is what process is a parent entitled to before there is a deprivation of parental rights, whether it's through a termination order, as it should be. If it's that bad, they have a constitutional option. Instead of a lifetime protective order, go file a termination. That's a constitutionally tested process. As the majority said in Santosky versus Kramer, it can't be that to terminate parental rights or to effectively terminate them, as Justice Ferris noted in her dissent, the standard is the same as for awarding money damages.
Would the constitutional issue be, or analysis be different if this order, instead of saying permanent duration, said duration of 10 years?
The question for me is there a permanent deprivation of parental rights?
10 years wouldn't be permanent, so you would concede that there's not a constitutional due process violation if it was 10 years?
No, I don't concede that, Justice Boyd. A firm conviction or belief, 10 years, if all the stars align in those 10 years, I may get my rights back. I don't think this idea that you can modify, if that's where we're going with this, is sufficient to cure the initial constitutional deficiency.
That's not where I'm going with it. I'm trying to figure out what I'm hearing from the petitioner side here is because it's permanent, you have to have extra protections constitutionally. And of course, then but 2 years you don't. And now you're going to get into that spectrum. Okay, what about 10 years? What about 9.5 years? What about 9 years? When does it become constitutionally significant?
This is a due process question. What process is a parent entitled to? A temporary order doesn't raise the same constitutional concerns. A 10-year order does. So it's not temporal, it's what is the deprivation. If the deprivation is you can't see your children for 10 years, you can't go within 100 feet of them, you can't communicate them, you can't communicate with them, there is a counselor somewhere out there that's going to decide whether in that 10-year period, that's a lifetime for a child.
But if it's only 2 years, then it's not a constitutional problem?
I believe anytime you're dealing with a fundamental right.
So 2 months would be a constitutional problem.
There are constitutional avenues for these 2-month periods or these two-year periods. They are temporary injunctions. They're issued all the time in family law cases. There are restraining orders that could be issued temporarily for the 2 months until there's an opportunity to assess and evaluate whether this deprivation impacts the fundamental right to care, custody, and control. That's what's at issue here. In a termination, there are service plans that you sometimes go through before your rights are terminated. There are permanency hearings, and whatever order comes out of that trial court is against the backdrop of a constitutional standard of proof. I see that my time is up.
Any other questions?
I want to make sure I understand what would happen on remand in your view. Would it be a remand for them to pursue termination only? Would it, if they want a lifetime protective order, can they do it just by having clear and convincing evidence and then the opportunity to put on the witnesses? What exactly on remand should happen?
So that's a multifaceted question. The issue on remand would be under a clear and convincing lens. Do these allegations, some of the records in the file, constitute a level of abuse that would constitutionally justify a termination? I don't think a protective order should ever be used to terminate parental rights. I think that those cases need to go back. Yes, it's a temporary and necessary instrument. You have to protect the kids. But if you want to take away a parent's right to forever see forever, worse than a termination, that needs to be done in a different proceeding. I don't believe just the standard requiring the trial court to have a firm conviction and belief about what she sees is enough in these cases.
Any other questions? Thank you, Ms. Guzman. We'll hear from the amicus in support of the Court of Appeals.
May it please the court, Mr. Bowen will present argument for the amicus.
Good morning, Mr. Chief Justice, and may it please the court. I want to start by thanking the court for the opportunity to provide briefing and oral argument on the significant issues presented in this case. The Court of Appeals did not err in affirming the trial court's entry of a permanent protective order against petitioner in this case based on the voluminous evidence at trial of mother's extensive abuse of her children, including abuse that was charged as a felony. The Court of Appeals also correctly concluded, based on the statutory framework of the Family Code, that a proceeding for a permanent protective order such as this, which again is subject to multiple avenues of modification, is not tantamount to parental termination such that the court should have applied clear and convincing evidence.
So as a preliminary matter, I just want to make sure I understand, that argument is that this is not a functional equivalent of parental termination, and for that reason it was okay. But do you agree at least that if something may be different from this, but if there were something that was a functional equivalent of a parental termination, then that thing would have to at least satisfy clear and convincing evidence and perhaps a higher burden even than that?
Yes, I think that's right. But I think to answer that question, we have to look at both the nature of the proceeding and the permanency of that proceeding.
So that question then gets to, well, is this a functional equivalent? But if it is,
then
yes.
Then I think you'd have to go back to the beginning in Santosky and this court's opinion in GM, and then look at the the background of how the courts have required clear and convincing evidence in termination proceedings. But in this case, under the Family Violence Protective Order statute in Texas, it is not equivalent to parental termination, such that preponderance of the evidence is constitutionally permissible.
Do you know, or does the record indicate why termination was not filed in this case?
I don't think the record does indicate, Your Honor, why. CPS was involved on a number of, or contacted a number of times.
They had been involved in the
or they were contacted. They never intervened as far as
I
the
thought
record.
the mother was cleared in some other, that abuse was ruled out in some other interventions of CPS.
There was testimony that CPS ruled out interventions, but it wasn't entirely clear in my reading of the record whether that was on all the instances or just on some of the instances.
Are you arguing that the mother got due process?
Yes, I think the Court of Appeals correctly concluded that under the Chapter 85.025 protective order, that the trial court was not required to apply a clear and convincing evidence standard. And I think that is the quintessential, to kind of crystallize the issue for the court, the question before the court, I think that the mother has presented to the court, is whether this requirement of clear and convincing evidence is necessary under Chapter 85.025. I think some of these ancillary due process arguments that are being raised were not properly preserved. I think the question before the court is whether in a lifetime protective order proceeding.
Well, this was not a lifetime protective order proceeding, right? Did the mother know at the time that all this was being discussed that it was going to be a lifetime order?
It is interesting because if you look at the original protective order that was filed, it did not seek a lifetime. So it's unclear in the record how we got from the initial protective order draft to the final order that was a lifetime.
So she didn't have notice that it could be well, I suppose anytime you show up in court, it could be a lifetime protective order because the statute is so general, but...
Yeah, the statute just says if it exceeds more than 2 years.
And it just says may, and there are no other parameters. Are you familiar with any cases that have fleshed that out, that have said when it would be an abuse of discretion to issue an order longer than a certain amount of time?
Not specifically on those contours of the timing. I think the question in this case is whether a lifetime protective order, or better put, permanent protective order subject to modification, and whether that protective order amounts to parental termination such that a higher evidentiary standard should have applied.
If the parties are arguing about a temporary protective order and the judge takes it under advisement and then comes back out and enters a lifetime protective order that nobody argued for and nobody knew they needed to argue against, is that a due process problem? Is that a lack of notice of what's at stake to the defendant?
I think under this is on, in my oral argument exhibit packet, page 4, I have the excerpt from section 85.025, and it says the court may render a protective order that is effective for a period that exceeds 2 years if the court finds that the person committed an act constituting felony offense involving family violence. So I don't think, the statute doesn't tie that to a notice requirement at the pleading stage. So I think that under the statute, a trial court could enter a lifetime protective order if it makes the requirement.
Do you think there's a constitutional infirmity in that regime that empowers the court to issue a much harsher sanction than anybody's arguing for, and harsher than the defendant is on notice that she might be subject to?
Speaking just in terms of lifetime protective orders, or as they relate to the parent-child context, or just generally?
Well, I suppose you can make it, it's much more acute in the context of parental rights, but you could make the point more generally that people are entitled to know what's at stake when they go in to argue before a judge, and if one side's arguing for X and I'm arguing against X, and the judge comes back out with Y, and I had no idea I needed to defend against that doesn't sound fair to most people's ears. I wonder whether that might be a due process problem.
I don't think so, because I think because the statute speaks of more than 2 years without any end, and if that's how the protective order proceeding was set up, that we were seeking a protective order that exceeded 2 years, then I think due process is satisfied.
Do you know if there are these similar types of protective order proceedings in other states?
There are, and it's sort of a mixed bag in other states. A couple states have held that this is de facto parental termination, and one or two states have held that it's not. So it's not, but the challenge with looking at other states, which is why I didn't include these cases in the briefing, is that their statutes are so unique that the kind of procedural mechanisms don't align nicely.
How are they different? How are they different?
Some of them deal with the type of conduct that can lead to a protective order. There's unique, like, neglect.
Ours does that too, right?
That's true, but I think when I was reading these other cases, and I'm happy to provide them in a letter brief if the court would like, but I found them to not be as applicable to our specific statutory regime here.
Are there any that allow lifetime protective orders against parents? Any other states' statutes?
I believe that I believe Vermont has or their courts have construed this as permissible.
Leaving aside the due process concept for a second, just in an ordinary case, is it an abuse of discretion for a trial court to grant more relief than anyone asks for?
I don't believe so. I think in the protective order context under this statute, because the protective order authorizes the statute authorizes a protective order that exceeds 2 years, and the protective order that was sought was exceeding 2 years.
Well, you might have a proceeding where an amount of damages is authorized up to $1 million, but you don't get $1 million if you don't prove it or ask for it. And usually we deal with that through the adversary system, where we say, unless somebody's arguing for it, the judge can't give it.
Right, and so I think in this context, because the trial court entered findings that it found that the petitioner had committed family violence that rose to the level of a felony, and so therefore it was entitled to enter a protective order that exceeded 2 years in duration.
I think we have some cases that say, yes, you may be statutorily entitled to do that in a case where it's requested, but if it's not asked for, it seems like that's an adversary system problem.
Yeah, I potentially would agree to that if it isn't sought, but I think
because then the judge is basically putting themselves in the shoes of the advocate.
Right, but I think again here, as long as the party seeking the protective order has sought a protective order that goes beyond 2 years and has put forth evidence to make that threshold statutory requirement of a felony offense constituting family violence, then I think the trial court is within its discretion to enter a protective order within the statutory time frame.
So there's no limit on that discretion. It can be however long you want.
Well, I think we could look at I think we could review the trial court's decision. The court could review the trial court's discretion based on the evidence under a legal sufficiency challenge. So I think you would still get to review the evidence.
I'm trying to figure out if there's an alternative here, because this is about protection, and in this particular case is protection of the children. And so let's say if a termination proceeding had been brought and the court were to have found that a ground plus best interest had been proven by clear and convincing, and let's say this mother's parental rights were terminated, would the protective function that we're talking about, would that still be in play? How would that work in terms of protecting the children?
And I think this gets to the essence of why the legislature decided to enact Chapter 85.025.
That's what I'm trying to get at.
Yeah. And I think the point of the protective order is to protect individuals, children, victims of domestic violence, a whole host of people from their abuser on a short order time frame.
Could a termination do that, a termination order?
A termination order could restrict access, but it doesn't necessarily restrict access. So this fills a gap, or maybe not a gap, but serves a different purpose than a termination order. Because again, it only touches the right of access of the parent to the children, to be around the children, for as long as the protective order remains in place. I think this is again where the uniqueness of a family violence protective order is distinct from parental termination, because it can be modified essentially in perpetuity. It can be modified by the person against who it's sought twice, so the mother here can move to modify it twice. And then this is on bullet point 5 on page 4 of my OA packet. On the motion of any party, the court may modify an existing protective order to exclude any item included in the order. So any of the children, the dad, any party to the protective order proceeding can modify that order.
So let's say if a parent's parental rights were terminated, and let's say an aunt adopted the children, okay? Typically, those rights are severed forever, and now this adoptive parent plays the role of a parent for all purposes. Could an order be entered at that point in time that would protect the children from being allowed to be with the mother?
Yes. I think the protective order can be entered against any person to protect any victim.
No, I'm saying if it wasn't a protective order, if the rights to the mother were terminated, this other party adopted, and there was concern that this party was going to allow the children to be with the mother, and the mother, let's say if evidence was proven, or if it was proven that that mother would endanger the child, then what type of protective orders would be possible at that time, or what type of protection through that avenue of termination as opposed to a protective order?
I'm not sure there would be an avenue through termination for that protection.
I mean, that's what I'm asking.
Yeah, I think the answer would be a protective order in that situation to protect the children.
If we ultimately conclude that the nature of the protection afforded to the victims here was tantamount to termination of the parents' rights, and so worthy of the application of a clear and convincing evidence standard, what is the appropriate remedy? Should we remand for a new trial for a determination under that higher evidentiary threshold?
Yes, I think if the court concludes that clear and convincing evidence should have been applied here, I think it should be remanded for a new trial under clear and convincing evidence because of Supreme Court and I think this court's authority too, saying that the litigants have the right to know at the beginning of trial what the burden of proof is and how that burden is allocated.
I wonder if you could help us walk through the Santosky analysis.
Yeah, be happy to.
Because there are three parts that the court looked at there to decide whether there's clear and convincing evidence that's required. And the first one is the nature of the right impaired, that the private interest affected. Would it or wouldn't it be enough on that part of the test that you're depriving the parent of companionship, care, and custody, maybe not quite completely control, as you point out, but certainly companionship, care, and custody? Would that rise to the level under Santosky of a grave impairment, even if there's some control that's still impaired, that's still allowed?
No, I don't believe so, because in applying the Eldridge factors in Santosky, the United States Supreme Court explained that whether the loss threatened by a particular proceeding is sufficiently grave to warrant more than average certainty on the part of the fact finder, i.e. preponderance, turns on both the nature of the private interest threatened and the permanency of the threatened loss. And so,
well, it's permanent here, we know that, and the nature is that the loss of companionship, care, and custody. So why is that not sufficiently grave?
But I disagree that it's permanent here because of the multiple avenues for modification, that including in the protective order itself that specifically contemplates modification. And so I think that it's not the same as termination, where you have one appellate right and then it's over and there's no modification. Whereas here,
but Santosky recognizes that there are also some rights that can fall in that bucket that can be revisited, like deportation, and there were some others, I think.
Yeah, and I think that that Santosky's discussion about the state seeking to not merely infringe on a fundamental liberty interest, but to end it, is what distinguishes that analysis in Santosky from here, where we're not extinguishing anything in a protective order. We're prohibiting the person from seeing their children for as long as the protective order remains in place. And
let me ask you about the second factor, the risk of error from the standard and the likelihood that a higher standard would reduce it. It seems like the risk of error is quite high here because you have these very vague may standards. And that was the concern in Santosky as well, is that you have these very vague standards that are susceptible to, difficult for the court to apply and could lead to different kinds of outcomes. And so if you've got a may standard and there's really no guidance for the trial court on how long this should last, Isn't that the same kind of problem we had in Santosky?
No, I don't think so, because in the application of the second factor in Santosky, the court also talked about the balancing of the safety of the child against the parent's ability, against the state's interest in going after that.
So that's the third factor.
Right, but I'm sorry, but the court also talked about allocating the risk in the second factor analysis. And here I think that risk is adequately allocated because the trial court has no discretion to keep the protective order in place if it finds that it's no longer warranted. That's in the Chapter 85 of the Family Code.
Well, there won't ever be such a finding unless somebody requests it, I guess. But it's permanent by its nature, so.
Right, but the fact that any person who's a party to the protective order proceeding or mother can move to modify it, and then upon that motion to modify, the trial court must modify it if it finds that there's no continuing need for the protective order. I think that distinguishes this scenario from a parental termination.
So that seems more like the first factor. I guess what I'm getting at is what the Santosky court said on that second risk of error factor is there are imprecise subjective standards that have a lot of discretion built in, and it just seems like that's what we've got here.
And I think there is
once you're beyond 2 years.
Yeah, I think there is a lot of discretion. Yeah, I agree with that.
If the mother had been convicted of the third-degree felony she was charged with, do you have a sense of what a likely sentence would have been?
On a third-degree felony?
I think she was indicted on a
third
third-degree felony.
I think that's 5 to...
It might be a little less than that, but
let's
say it's a few years.
Yeah.
A question that is occurring to me as a parent is, would I rather go to prison for 2 or 3 years, or would I rather be prohibited for life from contacting or being near my children? And the answer to me is clearly I'd rather go to prison for 2 or 3 years. We have all of these elaborate doctrines of constitutional law that have been developed to protect people's liberty interests when they're at risk of being locked up for committing crimes. And I wonder whether, at the end of the day, the kind of what's been done to this woman, whether she deserved it or not, is actually far worse than that, and is a greater intrusion on her liberty than would be a prison sentence.
I agree with the premise that being in prison for a couple of years is far better than never seeing your children again. I think that the difference in this context is that the protective order itself specifically contemplated reunification between mother and her children. It said, quote, that the children are to remain in counseling with a counselor that fits the needs of each child, and that the counselor for each child shall specifically consider whether and when the child is ready to begin reunification. So I think the protective order even went beyond the statutory rights for modification and contemplated another avenue for reuniting mother and her children in this case.
Let me just ask you this. I mean, we're not contemplating that there would be no way that a protective order could be granted in this type of situation. We're talking about simply heightening what's required to get it. Say, for example, by needing to prove by clear and convincing evidence. What's the downside of that?
The downside is that the legislature made the very specific policy decision to permit protective orders such as this under the Family Code, subject to a preponderance of the evidence standard, on a short time window to protect victims of domestic violence from their abusers. And so heightening that burden would interfere with the legislature's decision to enact this statutory
To protect
regime.
for a short time is one thing. To have a permanent order with, I guess this possibility that who knows, maybe one day when the children are 64, it will be modified, doesn't seem like that has any congruence with a judgment that for a short time to protect people, we need to have a lower standard. And we're talking about now a permanent order. On its face, it's permanent. I get your point. You're doing a very able job as an appointed amicus. I'm grateful for it. But that is not the same thing as actually saying that it isn't permanent, because it might one day be changed. It's permanent on its face. Until something happens otherwise, it's permanent. That doesn't have anything to do with protecting someone on a short term.
Right, and I think what I meant in short term was just in the 2-week period to get the protective order at the very beginning. And then moving into the how long the court can enter the protective order, the legislature made the decision to allow these to last in perpetuity, but only under the circumstances in which a person is found to have committed felony level family violence. So it's not any circumstance can you get a longer protective order. It's reserved for those instances in which the person
So the statute covers all measure of family violence. The clear and convincing evidence standard that applies to parental termination was added by the legislature because this court concluded that the Constitution required it.
Right.
And so if we're talking about that very specific kind of familial relationship, dating relationships are not protected by the Constitution in any particular way, but the parent-child relationship is a fundamental constitutional right. So would not the doctrine of constitutional avoidance at the very least suggest that for a protective order when it comes to parents and that goes beyond what seems like, well, there's a 2-year expectation, and then under extreme circumstances it can go beyond that. At the very least for that circumstance and for the parent-child relationship, would it not actually be a continuation of this court's precedent to say, no, the Constitution still applies even if you label it as a protective order, and then you add to that the due process clause, you have a double reason for constitutional avoidance. And then if the legislature really, really, really wants to say, no, we can take children away from their parents on a preponderance of the evidence for the rest of both of their lives, it can pass a law that says that, and then we can address the constitutionality of that statute if the legislature really wants that.
I think that in looking at how this court and the United States Supreme Court got to the decision that clear and convincing evidence was required, and this court's many subsequent opinions talking about termination, nearly always discussing this is terminating every right permanently, forever. And here, mother retains many rights from the final divorce decree. I've included a chart in my briefing
the right to be consulted about dental care. I mean, I get that.
I understand.
There's not nothing, but compared to seeing your child ever again for the rest of your life, I'd be glad to hear from my child's dentist.
Yeah, I totally agree. I think, but when we're speaking in terms, this court has talked about the bundle of conservatorship rights, and we're touching some of those rights. We have to still look at the remaining rights that are left unaffected by a protective order when we're speaking about the constitutional requirements on a protective order proceeding versus a termination proceeding.
Any other questions? Thank you, Mr. Bowen, and thank you for your willingness to accept the assignment.
Thank you.
Ms. Draper, you have 5 minutes.
May it please the court. As Justice Ferris stated in her dissent, a limited opportunity to later seek review of a continuing need for a lifetime protective order does not make a fundamentally unfair proceeding comport with due process. I want to address an issue that Justice Lehrman raised about the protective nature. If you have a termination proceeding, how do you then guarantee protection of the children? If there had been a termination proceeding here, it would be much more appropriate to issue a protective order because the due process rights were protected by the termination proceeding. That termination order could include injunctions against the mother from seeing the children if it had been issued, but if it is believed that more serious protections are necessary, not coming within 500 feet of the school or whatever the case may be, we would not have the same constitutional concerns that we have here. Justice Busby, you mentioned about the risk of error. I agree that the risk of error is extremely high, and it goes beyond just the may language. The preponderance of the evidence standard and lack of a jury trial here, the risk of error is tremendous. The record as a whole, if we look at all of the due process concerns within this record, this woman was not allowed to really mount a defense based on the record that we have here.
Well, she waived her Fifth Amendment right and testified on her own behalf and said these allegations are simply not true.
That is true. However, the trial court hamstrung her at every step of the way from putting on a proper defense in this case. And as a result, it has now been 4.5 years since she has seen or spoken to her children. There was not a criminal conviction then, and public records show us there is not a criminal conviction now. But we have this protective order, and the burden has been shifted to require her to prove that it is no longer necessary. How is she going to do that in the shoes that she is in this case? The process was fundamentally flawed. That is where her constitutional rights were violated. The trial court used the lowest burden of proof to grant the most extreme remedy. It is like she was charged with assault and walked out convicted of murder. The legislature's decision to issue a preponderance of the evidence standard in this case does not make it per se constitutional. And there are so many constitutional infirmities here that really need to be addressed.
I understand that you've pointed out, and amici have pointed out, multiple constitutional infirmities. But the only one that the Court of Appeals looked at was the clear and convincing evidence standard. And squinting, we can potentially see that in the trial record. But any of these others were not pointed out to the trial court and not argued in the Court of Appeals.
There were other constitutional infirmities argued in the Court of Appeals. The first 2 points of error were the preponderance of the evidence standard and then the allegation of a felony without the protections of a criminal proceeding. Here, she did not have the benefit of the Fifth Amendment. In a criminal case, she can plead the Fifth and the court cannot hold it against her. If she had chosen to plead the Fifth in this case, the trial court could have assumed everything she said would have been bad. She had no choice but to waive the Fifth Amendment in that case. Were you going to say something else? I'm sorry. Okay. So we also raised, there's no, the short timeline. We raised I know the lack of a jury trial was raised. We raised the issue of the failure to offer a burden, to allow her to do a burden of proof. We actually had 4 issues in total. One of them was sufficiency of the evidence, and we addressed the various issues with what happened in the trial court and those arguments. I know the constitutional issues are the big ones that we're here to talk about today. We are requesting that this protective order be vacated. It has been 4.5 years since this woman has seen her children. One of the children is now 19 years old and an adult. The process as a whole was wholly deficient, and there are constitutional means to obtain additional protection if that order is vacated. If the father believes that a protective order is necessary, he has every right to go seek an additional protective order under the standard that this court sets forth. There is no statute of limitations on when you can do that. A remand is not necessary. It should be vacated. There's also the modification proceeding related to the children that are still not of majority yet, and protections can be had in that realm. If the father believes a termination is warranted under any ground under the family code, then he is certainly able to go seek that termination under whatever grounds he believes that he can prove. But at the end of the day, this was unconstitutional, and we are asking this court to vacate the protective order and find that you need both a clear and convincing evidence standard and a conviction or deferred adjudication of a crime involving family violence with serious bodily injury or death. I see that my time is up.
Any other questions? Thank you, Ms. Draper. The case is submitted. The court is pleased to have been able to conduct oral arguments here at the University of Houston Law Center, and we will enjoy interacting with you in the rest of the morning. The marshal will adjourn the court.
All right. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned. Thank you. You may be seated. Ladies and gentlemen, we will have a question and answer session here in a few minutes. The court will come back out in about 5 minutes. The dean is going to be running the question and answer session, as I understand it. So if you want to ask a question, feel free to take a seat, and the dean will be back in a few minutes, as will the court. So again, we'll have a question and answer session here in just a few minutes. If you want to start finding a place to sit down. And as I said, the dean will be back and will be passing the mic around if you have a question to ask.
That you may have, so please don't leave about the process, so please stay, all of you. So it's really great the judges are going to be doing this and making themselves available and talking about the legal process, the hearings, and whatnot. It will be a great educational experience for all of you, so please stay. Huh? Nice to meet you. What's your name? Oh, okay, yeah. Oh, Marisha, yeah. Good, great. Oh, yes. On Zoom. Yes, that was a long time. Nice to meet you in person. Absolutely.
Yep, please.
That's been great. We really want. First of all, hear me? Can you hear me? So first of all, I want to thank the justices for being here. It was really an amazing oral argument, and also the advocates were amazing. I learned so much about salt mining, more than I ever thought I would know or want to know, which is great, and also about protective orders, which is also amazing. So this is an opportunity for the justices. They volunteered to come back and actually speak to you. Many of you are law school students and pre-law students and advocates, lawyers, et cetera, and professors. So any questions you may have, I would imagine they can ask any question. You can decide to say yes or no, or not answer the question, or answer the question. So any questions anybody have? Don't be scared. Okay, great. Luis.
Good morning, Justices. Eduardo Alvarez. I'm an LLM student, just graduated, a foreign trained attorney. One of the questions that I had, it was on the protective order case. I heard that it was you, Justice Busby, who asked counsel about the discretion of the judge. If the judge could go above what the petition were made. And my question would be like, don't you think that under the perspective and the public interest of the best interest of the child, the judge actually have discretion to go on a protective order that further what it was claimed? Thank you.
Justice Lerman?
Well, we really can't comment on this particular case, is the problem. So let's try again.
We're going to have to give the other side an extra 10 seconds now that you got it.
But great question. Any other questions?
It was a very good question.
Me too. Oh, great. Okay. I'm going to be Oprah today.
Chief Justice and Your Honors, thank you so much for being here and for taking questions. It's an honor. My name's Josh Mitchell. I'm a just basic UH pre-law, I guess, student. And I think the question in generality, I understand you can't answer particulars, but it sounds like the second case on the protective order, right? Is it just basic due process that we're talking about? Is that kind of the consideration that we're looking at in that case? I didn't hear that verbiage a bunch, but it sounded like I was kind of hearing that and I was discerning that in an applied way. Are you able to speak on, is that the primary way, like was the mother, is the issue that she did not have enough due process, and because of the capacity or the specific way that those charges or whatever was brought forward? Are you able to speak to that? And if not, then I totally understand. But thank you for being here.
Great question. See, our pre-law students are amazing too.
Well, again, as Justice Lerman says, we can't talk about the case, but her contention is that she didn't get due process in the proceeding. And of course, the question, as you heard the arguments, and the parties have all submitted briefs ahead of time as what does that mean? And so that's part of the issue that we're deciding is how is it affected in this setting.
Well, let me ask you all a question that you may be able to answer. Is so how does this process work? So for our students, pre-law students especially, but law school students, you have the arguments, and then what happens after that, right? How does the decision come down, and what's that process like?
Justice Boyd.
Sure, Chief. Good morning. Thanks again for having us here. It's been a fun day already. So we are a court of discretionary jurisdiction, which means we don't have to take your case, even if you file it on time and pay the filing fee, which sounds a little odd, but it's like the U.S. Supreme Court is the same way. They are a high court of discretionary jurisdiction. The theory is, speaking of due process, you get one shot at an appeal. You go to the courts of appeals, and we take the cases that we think the Court of Appeals might have got it wrong. We usually think that, but not always. But more importantly, we think it's a really important issue, even beyond the parties in that case. So a lot of the questions you heard us talk about in both cases today, we were thinking in terms of how are these rules that you're asking us to apply here going to affect other mineral leaseholders and other situations involving minerals and so on. So that's the first step, and that's we spend, we'll have 20 or 30 of those petitions every week that our votes are due on. Thursday at noon every week, we have 20 to 30 petitions where we all vote, do we think we ought to take this case? If we decide that we should take the case, then that's called granting the petition. And then and by the way, we get about 1,000, 1,100 petitions a year, and we take about 100 of them. We decide about 100 cases. So that's about 10%, which sounds bad, but the U.S. Supreme Court gets like 13,000 a year and takes 70 of them, so I can't even do the math on that one, but it's less than 10%, 1%. If we take your case, we literally draw blue index cards once we've granted 9 or more cases and we're sitting around our conference table. We'll literally draw to see which one of us is going to be responsible for writing the court's opinion in that case. Totally random. Some courts, the Chief Justice assigns it. The U.S. Supreme Court is that way. In our court, the tradition has always been we just randomly draw. So what you guys don't know, and I have to admit, I argued a few cases to this court before, and I didn't realize it till I got here. When you're standing there arguing, one of the 9 of us has already been assigned the job of writing the opinion for the court in that case. We don't let you know who that is because we want you to argue to all of us, not just one of us. But so what will happen, Dean, after this is we have conference, what is it, a week from Tuesday? A week from Tuesday is our next conference where we sit around a table. And whichever one of us drew, say, that first case, sometime before that conference, usually by the Friday before that conference, so a week from Friday, we will circulate a memo to the rest of the judges and say, here's how I'm leaning. Here's what I think we should do with this case and why. Usually a short memo, but, well, sometimes a couple aren't so short, but they do have nice intro paragraphs that tell you where it's going, which is nice. But most of us write them pretty short, just to say, here's where I think we ought to go and why. Well, then we come at conference and we discuss it. Whoever drew it will say, well, as you read in my post-sub memo, here's where I think we ought to go and why. And we go around the table and everybody says, I agree, well, I'm not sure I agree, and here's why not, and so on. Well, then you leave that conference and you're responsible for coming back 2 conferences later, basically 2 months later, with a full draft opinion doing what you said you were going to do. And then we conference it again. Everybody reads it and they go around the table and say I'm with it or against it. So that's the basic approach. Now, it may be that you say, well, here's my draft opinion 2 months from now in the second case today or whatever, and you get 5 or more people say I disagree. Well, at that point, it gets assigned to one of them to write the opinion the opposite way, and you've got to turn yours into a dissenting opinion, which happens within usually a month after that conference. So that's a basic overview of the process.
Let me just comment too, and one thing that was said, and that is that once we at that initial conference say where we're leaning, and we haven't really done the in-depth internal briefing that we're going to as we're writing. And so sometimes as you're writing opinion, you end up someplace where you didn't expect to be. So you may think at that initial conference that you're going to end up here, but after you get into the weeds of it, and those of you in law school know what I'm talking about, you may end up over here. So we're not bound. We just, let the writing take it where the law would have us go.
Let me also say that part of that process that Justice Boyd went over, the real difficult portion of that is deciding out of those 20 to 30 cases a week, which ones do we take? And, I've always answered that question way. I don't know necessarily the process, the mental process that my colleagues go through to make that decision, because we all have to make that decision and vote. And once you do that, then you count the votes, and that's the way it goes. And there's a couple examples of, maybe what some of us look at. We may look at the underlying precedents set by the Court of Appeals. If there's a conflict between courts of appeals decisions, that's usually a good indicator. And there's, whether or not there's, as he alluded to, important constitutional issues that are important to everybody in the state, or at least a large portion of the state. And then, of course, the catch-all, which I think most of it call is whether or not it's important to the jurisprudence of the state and what that means. And it's really kind of a fun process to go through, but it is so important. And it's interesting how a lot of the times the 9 of us come up with the same cases. And so anyway, I throw that out.
Any other questions from the audience? Yes, good.
Hi, my name is Morgan, and I'm a 1L here at UH. And Justice Boyd, I saw that you went to ACU. Go Wildcats. My question is for any and all of the justices, though. Did any of you never in your wildest dreams imagine that you might end up on the Supreme Court of Texas? And if not, how do you think you made that a reality?
That was going to be my question. Great question.
Sure, that's a great question, and you don't, part of the way the system works and is supposed to work is that you don't get to decide for yourself whether you get this job. You're either appointed by the governor, which is completely outside of your control, or you're elected by the people, which is also outside of your control. There are certain things you can do to put yourself in a position where you might be chosen for something like this. Justice Boyd and I were the general counsel. He was the Governor Perry's general counsel, and I was Governor Abbott's general counsel. And so we were working with the person who ended up having the ability to appoint us. But just generally, the advice that I would give to, if you want to be in a position to achieve anything, whether it's a position in public service or anything else, work hard and commit yourself to the mission of your organization. So whoever you're working for, you need to demonstrate to them that you care about what they're doing, and that you're going to commit yourself to that and work hard for that, as opposed to it being all about you. And if you find something that you can invest yourself in and feel good about really diving into, then you're going to want to work harder, you're going to do better work, and you're going to find yourself more useful to the people in charge, which then helps you move up the ladder, whatever that ladder looks like for you.
Any other answers? Good. Justice Devine.
The chief often calls me the outlier because, I was elected. And when I went through law school, I worked for a big oil company here in town, and I went to law school just to stay off the streets and out of trouble. And I, had no intention of practicing law. The idea of, I had a good buddy that worked at Shell. He clerked for one of the members of the court, and I thought he was crazy. He took a 70% pay decrease and went on to clerk, and is highly successful here in Houston. But I, for one, had no intention, had no desire, as I worked my way through business, mainly, had my own firm, and eventually did practice a little law and thought, hey, this is interesting, fun, but certainly no ambition to be on the court. And it was through the political process and some of what Justice Blacklock said about being true and faithful to whatever it is, whoever it is you're working for, or those values that you hold, stick to them and stay in the fight. And now this is my 12th year. So it goes to show you that Now, Justice Boyd appointed himself. He hasn't said that, but I'm going to let him respond to that. But he's one of those examples and so forth. But,
so, Justice Boyd, do tell.
Some of y'all aren't old enough for this, but they call me the Dick Cheney of the Texas Supreme Court. You remember he was asked to head up a search committee to decide who the vice presidential candidate would be, and lo and behold, his committee picked him. No, I did serve as general counsel for Governor Perry, but I had then moved in. I was his chief of staff, and when Dale Wainwright called and said he was retiring from the court and the governor would need to appoint someone, and I told the governor, and the governor said, well, I want you to head up the search committee and let me know who I should appoint. You know, they say if you're explaining, you're losing, so I probably, I can explain, but my wife had 3 kids at private universities, 2 at Abilene Christian, 1 down at Savannah College of Art and Design. I had left a very good paying senior partner position in a big firm to go work for the governor. I committed to 2 years. And so I knew I was in a position to be considered for the job, but we, in our case, prayerfully decided not to. And so we interviewed I interviewed with a small appointments group, 20 some odd people, and gave the list to the governor and said, and put at the top of the list the 4 people I thought he ought to really focus on. And a couple weeks later, he and I were in some meetings, and when those meetings ended, it was just the 2 of us in the room, and he said, oh, by the way, Jeff, I've looked at that list you gave me. Man, that's a great list. We got a good group to pick from, but I'm not going to pick any of them because you're going to be the next justice on the Supreme Court. And I said, no. And we prayed about it. I need the money that I get with 3 kids in private school, and I don't want to be the politician. I like being the lawyer for the politician. I had worked for him. I had worked for John Cornyn at the AG's office and Greg Abbott at the AG's office. I don't want to be the politician. And in a way only Rick Perry can do, he kicked his boots up on the desk literally and said, Jeff, I'm going to help you with the politics, and God will take care of the money. And so, of course, I said, well, give me till Monday, and I called him Sunday and said, of course I'm going to take that. I could never say no to that. So, yeah, I appointed myself.
Well,
sounds like it was an act of God.
Any other questions? I see one over here. SBA President.
Yes. Good morning, Your Honors. My name is Duncan Reedick. I'm a 2L here, and as Dean Baines said, I am the president of the Student Bar Association. To make sure I didn't lose track, and as this is sort of like a cold call as a fresh 1L, I wrote my question down. So from law students to lawyers having just passed the bar, we're all honing in and developing our skills as advocates. As justices of the Supreme Court of Texas, you've all had successful careers as legal advocates, but more importantly, you've seen your fair share of argumentation. Could one or more of you speak to how you define successful advocacy and what that may look like?
Justice Busby.
Well, thanks, and it's a pleasure to be back in Houston and to be here at your beautiful new building. So we're grateful to have this opportunity. And I think there are several things that you can do in that position to help hone your advocacy. I think good advocacy to me is not only expressing your position clearly, but being willing to take questions, and you saw a lot of that today. I think sometimes, certainly when I was a student, I thought about, getting up and giving a speech, and actually, the most use you can be to a court that asks a lot of questions is in answering those questions. Because we've already read your briefs, and so the questions are our opportunity to say, your opportunity to get an insight into where we may be having trouble with your argument and where you can help convince us of your position. So that's really the most valuable opportunity that you get as an advocate is to get a question from the decision maker and do your best to answer it. And if you forget something, we've all done that. If you forget something on the spot, you can send a letter in later and say, oh, by the way, here's some more things that I thought of. So don't worry about, you know, just being able to remember everything on the spot. So I think another thing to do is look at a lot of different styles of advocacy and see which one fits you. There are a lot of different ways to do this. You saw a lot of great examples today. And I was fortunate early in my career to see a lot of different lawyers argue cases and see, you know, just from learning what's effective and you know, with experience what's not. Also, do some moot courts with people before you have a chance to go and argue. It's great to get different perspectives and get different people to ask you questions so that you feel comfortable with the case and you can anticipate the questions that might be coming to you, plan out your answers for those. That's going to make you able to really focus your answer and get the most out of the limited time that you have available. So those are a few thoughts.
We have time for maybe 2 more questions. So let's go back. There's one. State your name.
Hello, I'm Roman Panda. I'm a 1L here. And Justice Boyd, you gave us kind of like the big overall picture of what the process is like. I'm kind of more interested in the magic of it all, the opinion. Justice Blacklock, you talked about how it's important to stick to your values. And in law school, we're learning there's a lot of values in law school. We value factors like precedent, procedural history, history in general, policy, and legislative intent, and more. And I was kind of wondering, how do you weigh these factors, and how do you determine which factor is more important than other factors, in your opinion?
Justice Blair.
So are you talking about in terms of a judicial philosophy?
Like when you're making your opinion, your judicial philosophy on what factor is weighed more than other factors.
So ultimately, you know, we're not policymakers in the sense of adopting a particular position, our own personal preference for what the law should be, or a particular group's preference about what the law should be. We are not the lowercase p, we're not part of the political branches of government. So what is our job? Our job is to follow the law as written. And in doing that, what's the best approach? Well, you have to study the facts of the case, because that's going to bring the uniqueness of the case to your door. When you write the opinion, there won't be another opinion with exactly these same facts. And then you have to think about the rule of decision in the case. And sometimes that's a contract where the parties have bargained for that rule. And then you look to the terms of the contract and say, what did the parties intend in their language that they used in both sides agreeing to this contract? And then sometimes it's a statute that provides the rule of decision. And when a statute provides a rule of decision, you do the same thing. You look to the statute. And you may look to how that statute has developed over time. So not legislative history necessarily, but the history of the statute itself. What did it look like 100 years ago if it was in existence 100 years ago? If it just came into existence, look at the context of the world it was in when it was adopted. But mostly just look at the words of the statute and try to apply that rule of decision to the facts in your case. And then sometimes we have precedent, as you mentioned, and precedent can help, because if we decided the case the same way, a similar case the same way 5 years ago, you know, that's going to inform our decision in this case. Similar facts will inform a similar decision. Why? Because one of the things that the rule of law likes to do is provide certainty and settled expectations, so that when a statute is applied in a trial court in El Paso, or in Houston, or in Beaumont, or up in the Panhandle, or in Dallas, the statute is applied the same way consistently. And so departures, applying it inconsistently, there has to be a difference. There has to be a factual difference, an amendment to the law, something that requires a different rule of decision in the case in front of us. And we could have a whole hour or more about constitutional law and how to make decisions based on the Constitution, but I'll leave it there. It's similar, though. Try to hone in on the rule of decision for your case, and then think about how the facts presented apply given that rule of decision.
Justice Young, you want to?
Yeah, you can take the constitutional part.
Well, I mean, what else could I say? Maybe I'll say the question about how I got appointed. This probably never happened to anybody else, but I was appointed when Justice Guzman, who argued before you all today, left the bench. And the governor called Justice Bland, said, "Jane, who would you like to sit right next to you on the bench and in the conference?"
This did not
and she answered him, and he said, "Man, she said, there's only one possible answer." And he said, that's a great choice, but I think I'm going to appoint Evan instead. And on your question, to me, almost every document in the law, and most of what we are dealing with are texts. Justice Blaine said, statutes, contracts, deeds. We had a deed case, wills, the Constitution, and our job is to figure out what the words in that document meant at the time that the document was promulgated. If it's a public law question, a statute of the Constitution, what would an ordinary person of reasonable intelligence who speaks the English language have understood that text meant, and how it would bind the people of our state or our country? If it's a private law document, what would reasonable people thinking that they were now in a position to determine whether they owned the minerals underneath the ground or the ability to buy something at a certain price, what would reasonable people have thought, particularly if it's going to be something that's recorded so that other people who might in the future, 100 years later, decide they want to buy an interest in that? Well, it can't be some secret meaning that nobody could ever have known. That would defeat the whole purpose. That you buy this thing, I've got this diary from the original grantor, and he said that actually when he said 1/8, he meant 1/88. Trick. No. It says 1/8. It's recorded. We know what that means. It's not always as clear, by the way, that 1/8 and 1/2 of 1/8, for example, means what you might think. But the inquiry is, what would it have meant to reasonable people at the time? And so that is what will generate the rule of decision that Justice Bland talked about. We're trying to figure out so that we can provide maximum clarity. That's the most important job of this court, is to provide clarity so that all of you, when you go into practice, you're going to have clients and they're going to come to you and say, I would like to be able to knock down this building and build a better one. Can I do that? And if you say to them, well, certainly you can, and then in 7 years after litigation, when the Supreme Court of Texas will balance all of these factors, you might actually owe $10 million in penalties and go into bankruptcy. Or maybe it'll be great, here's my bill for my services rendered. That's not a really great thing for your client. And if we do our jobs properly by looking at text and giving precedents that provide maximum clarity to the lawyers, in turn the people of our state are better off, because your job is to serve the people of the state. Oftentimes people who really desperately need advice, people who might lose their children, people who might be living paycheck to paycheck and feel that they're being fired unjustly. They need to know whether if they take this step or that step, something bad will happen to them. And our job is to give you the tools to serve the people of our state so that the rule of law is what governs in the most intimate details of our life and in the details of public life that affect all 30 million of us. And the text almost always is what we work with to try to do that honestly and fairly and predictably and clearly. And then if we do that, whatever the outcome, that's not part of our job, is to care who wins or even to like the result of our ruling, but to believe that it's correct based on what the text of the law, private law, public law says.
Let's do one more question. Let's go up here. Is anybody over here? I don't think anybody over here. Anybody over here a question? No? Oh, all the way back there. Okay, let me get there. Let me do the guy all the way in the back.
My name is Wael, and I'm a law student at the University of Houston. The question would be, what is an advice or the best advice that you would give for the students that are applying to law school, and what is the best way to manage the pressure of applying to law school?
It's so great to have pre-law students here. the things that we do best is prepare our undergraduate students for law careers. So questions like, what can we do as a student to balance all these things and apply to law school and have the best application possible? It looks like you have an answer.
Great question. Yes, the chief has assigned this one to me, and it's great. It's a great question because I love to give advice. I'm glad you asked for some. I think you are right to go through this process, looking at law school on your horizon in a mature way, which is to say, this is going to be challenging, right? That tells me you're a realist. And I think that is a healthy thing, right? Understand what you're coming up against. And then work really hard. That is going to be the answer, whatever path you choose to go down. It's certainly the answer in law. Law school is difficult. You're going to have to draw on some grit. You're going to have to study hard. You're going to have to develop some writing skills, develop oral advocacy skills. These are going to be new things. And so I think you commit yourself to your mission, which is to do well and to grow in law school. And I think while you do that, you want to be mindful too of the things outside of the law, outside of the classroom, that bring you joy, that give meaning to you in your life, and really commit to not ignoring those just because you are in law school and it is demanding and time consuming. So that might be, in any particular person's case, that you love to run or play tennis. Something physical, I think, is very, very good to hang on to because of the really important benefits of physical exercise. But it might be your church or synagogue. It might be something completely different. But things that bring you joy, keep those in your life, even through law school. And then I would say finally, and probably most importantly, is to not become a silo. Law school sometimes feels competitive, and I think my advice is to sort of work against that and do be intentional about building community within law school, and also maintaining real meaningful, deep connections with people, your family, your friends, other people, that you can reach out to and draw on when finals come around or when you face any other difficult moment in law school.
Great. So I think that concludes the session with our justices. Let's give them a round of applause. And one thing I think that we've learned from this process is not only do we have incredibly smart and talented justices on our Supreme Court, but they're real people, right? That's, I think, clear from the conversation we've just had. And they were people like our students and our pre-law students. They are people like you that you can aspire to be them someday. So again, thank you so much for being here and providing this opportunity for our students, our pre-law students, law school students, faculty, staff, and alumni to witness law in the making and law in the interpretation. Thank you so much. So now there'll be some photos with you all. So where's our photographer?